right. This is the case of the people of the state of Michigan versus Tyler Lee Miller, case number 254935ST. Appearances, counsel, starting with the prosecutor.
Denise Standard on behalf of Mr. Miller.
Ms. Standard appears by Zoom and Mr. Miller appears here in the courtroom. We are here for a pretrial. Is there any resolution in this matter?
Your Honor, an offer has been made that if Mr. Miller pled guilty to driving while license suspended second offense, the state would dismiss the no insurance, and Mr. Miller is ready to accept that offer.
Ms. Carey?
On the offer sheet, it also says that he would be responsible to no proof of insurance.
Oh, sorry, I must have misread that one.
I will dismiss that as well for a plea to DWS second.
All right, so we'll plead to count 1, dismiss count 2, and the civil infraction.
Correct. It wasn't a civil infraction, that was an offer.
Oh, okay. All right.
Offer was to a civil infraction, but
All right.
I'll let that go.
Okay. Mr. Miller, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it? Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Do.
Sir, it's my understanding that you'll be pleading guilty to count number 1 of operating while your license was suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000 or up to $1,000 in vehicle mobilization. In exchange for that plea, the people will dismiss count number 2 of operating without security or insurance. Is that your understanding of the plea agreement?
That's correct.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
No.
Back on November 24th of 25, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you remember reading and signing the advice of rights form in this case, talked about your rights to an attorney and your rights to a trial?
I do.
Did you understand those rights? Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up those rights? You won't have a trial of any kind. Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes.
Ms. Carey, are you aware of any other promises, threats, or inducements not made part of the record? Ms. Standard?
No, Your Honor.
Then Mr. Miller, to the allegation that on or about November 24th, 2025 in Herring Township of Wexford County, how do you plead to operating a motor vehicle while your license was suspended, denied, or revoked as a second offender?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on November 24th, were you operating a motor vehicle in Herring Township?
I was.
And prior to, or while operating that motor vehicle, had your license been suspended, denied, or revoked?
It was.
And is it also true that you were previously convicted of operating while your license was suspended, denied, or revoked on October 1st here in this court?
Yes, it is.
Do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules been complied with?
Yes, Your Honor. Yes.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Miller, I find you guilty of driving while your license was suspended, denied, or revoked as a second offender. Pursuant to the plea agreement, the operating without insurance will be dismissed. Are we able to sentence today, Ms. Carey?
Yes.
Any allocution, Ms. Standard?
Yes, Your Honor. Mr. Miller is suspended or revoked until 2030. He did attempt to see if he was able to get that back. He found out he cannot. However, Mr. Miller received a job offer working for the pipeline, doing surveying in Abilene, Texas. His start date will be coming this week. So he hopes to be able to accept that offer, move there. Part of that job is he would be residing with a high school friend who is the supervisor there. And they will be providing all transportation to and from work. So Mr. Miller not be driving during that time, as he knows he is not supposed to be. If jail time were to be issued in this case, Mr. Miller would lose that job position. There is a presumption of no jail with this kind of offense. I do realize that this is not his first offense driving. He realizes that, he understands that. But if the court would be willing to do fines and costs, he indicated he could make that payment in full within a month, because he believes he would be moving to Texas, starting that job, and would be able to make that payment in full. So I would just ask that the court consider that.
Thank you, Ms. Carey.
Thank you. I appreciate that he understands and knows it, but it doesn't prevent him from driving because this is his ninth driving while license suspended conviction. Or to consider that. Thank you.
I noticed that the complaining witness is the motor carrier officer. Is this was it a vehicle or was it a normal
Yeah.
traffic stop?
Commercial truck with Miller. It was a truck that wasn't registered or it didn't have a insurance. It was registered to, or it had the Miller drywall name on it and it says private carrier. Yeah, it was a commercial truck.
Why was it stopped? I assume because the
The
plates were run.
Because the lights weren't working, brake lights.
Mr. Miller, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Yes, sir. I really just need to get out of this town and get going back on my feet. It's been pretty rough for the last few months. I know I haven't been doing the right things. I just need to get away and start over again. I don't know. It's just been rough for the last year, I guess.
When did you find out that your license is suspended till 2030?
A few months ago, I got a letter in the mail that said I cannot apply until July of 2030.
Do you know why it's suspended?
I'm assuming because I keep getting in trouble. I haven't had it for probably 15 years.
Well, as we went through in the last case, and as Ms. Standard mentioned today, there is the presumption that these cases do not carry a jail sentence, even though they are subject to a jail sentence. The Court of Appeals has instructed the courts that in order to impose a jail sentence, this case must be more egregious than any other driving a license suspended case. However, that is a rebuttable presumption. The court has before it somebody who is on their 9th driving a license suspended, was just in this court about a month and a half prior to picking up this driving a license suspended case. He was operating a commercial vehicle and the lights were not working. Therefore, the court does find that there is reasonable grounds to overcome that presumption. Sentence in this case will be 15 days jail with 0 days credit. Because I am imposing a jail sentence, I will keep fines and costs to a minimum. There is a $75 crime victims rights fund fee and $50 state minimum fee. The court will waive the attorney fee as well. You are appointed, correct, Ms. Standard?
Yes, Your Honor.
All right, I will waive the fines, costs, and the attorney fees. Mr. Miller, any balance that remains unpaid for more than 56 days will have a 20% penalty added to it. And because I have imposed a jail sentence, even you do have the right to appeal that decision. And if you decided that you wish to appeal it, but could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. All right, you'll need to go with the bailiff. All right, this is case number 25-5055 SM, the people of the state of Michigan versus Skylar William Burris. Appearances counsel, starting with the prosecutor.
Courtney Lawrence on behalf of the people.
Allison Cass on behalf of Mr. Burris.
And we are here for a pretrial, and we're also here for an arraignment on an amended complaint. So let's do the amended complaint first. Ms. Castles, were you aware of the amended complaint?
I am, Your Honor.
All right. Mr. Burris, I have an amended complaint that alleges that on or about December 8th, 2025 in Cedar Creek Township of Wexford County, it is alleged in count number 1 that you committed the offense of domestic violence aggravated. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentence may be imposed if it happened in a place of confinement. The prior charge was for a domestic violence only, which is the 93-day misdemeanor. Do you understand the new charge and the potential penalties for that?
Yes, sir.
You do have the same rights that you had back the original arraignment, which includes the right to an attorney. So we will go ahead and enter the not guilty plea on your behalf. We will continue the appointment, which brings us then to my next question. Is there any resolution in this case?
There is, Your Honor. It's my understanding the defendant is going to plead no contest to an added count of domestic violence. Sentencing under 4A. In turn, people have agreed to dismiss the aggravated domestic violence.
And the reason for the no contest plea?
I believe the defendant does have pending charges in Traverse City as well as possible civil liability.
That is correct.
This occurred before the charges in Traverse City, though, correct?
Correct.
So how would that have a bearing on this case?
It was mainly for the civil liability, but with the pending case in Traverse City, it was just in case it would have any repercussions.
All right. Mr. Burris, have you heard what the attorneys have said the resolution in this case is?
Yes, sir, I have.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
So help me God.
It's my understanding that you'll be pleading guilty to, you'll be pleading no contest to domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 if it happened in a place of confinement. Do you understand those potential penalties for the plea?
Yes, sir, I do.
Now, it's my understanding that you'll be pleading no contest. There's only a certain number of ways that the court can accept a no contest plea. And essentially what no contest means is that you're accepting the responsibility without saying that you're guilty. In this particular case, it's been presented that the reason for the no contest plea would be potential civil liability. So what the attorneys are telling me is there's the potential for the alleged victim in this case to turn around and sue you civilly for whatever arising out of this occurrence. And that by entering a guilty plea, that plea would be able to be used against you in a civil lawsuit. However, by pleading no contest, you would not have that same exposure. Do you understand?
I do understand, sir.
Now, in order to accept a no contest plea, I would have to review a document, presumably it's going to be a police report, to determine whether or not there's a factual basis to accept that plea contained in the police report. I would also be able to use that police report for sentencing. Do you understand that?
I do understand, sir.
Now, you also have an agreement with the prosecutor, and that agreement is that you would be sentenced under 4A. The 4A just references a statute, but what it basically says is I would put you on a period of probation. And if you're successful with all the terms of that probation, this charge would not show on your public record. However, if you are unsuccessful, the court could revoke the 4A protections, and then that charge would show on your public record. Do you understand that?
Completely fair. Yes, sir.
You also understand that even though it might not show on your public record, it would still show on your law enforcement record, and the prosecutors would be able to use that to enhance should you receive another domestic violence charge in the future.
Yes, sir, I understand.
Now, I feel as though there's a lot of caveats to this, but do you also understand that that's an agreement you have with the prosecutor, not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
I do, sir.
Knowing all that, then, do you still wish to proceed with the plea? Back on December 8th of last year, were you on probation or parole?
I was not.
Were you on bond?
I can't remember, but I don't think I was, no.
So the only thing I show in your past is in 2017, you had a juvenile matter. Is that correct?
That's correct.
All right, so you would not have been on bond.
I was not.
Do you remember reading and signing the advice of rights form that talked about your rights to an attorney and your rights to a trial?
I do remember.
Did you understand those rights?
I did.
Most importantly, do you understand that you have a right to a jury trial, that by entering a guilty plea today, you'll be giving up that trial and you won't have a trial of any kind?
I understand, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
That is correct.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
Ms. Lawrence, do we have an exhibit for me to review?
Yes.
All right, I've been provided with and marked as People's Exhibit number 1. It is a incident report from the Office of the Sheriff for Wexford County, case number 832502269. Ms. Lawrence, do you move for its admission?
Yes.
Any objection, Ms. Castles?
No, Your Honor.
All right, give me a moment while I review that. People's 1 is received. I have reviewed the People's Exhibit number 1, and I did note, Ms. Castles, that the exhibit does potentially lay out a self-defense claim. Are you waiving any self-defense claim in this case?
We are, Your Honor.
Do counsel believe that People's Exhibit number 1 forms a factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Ms. Castles?
Oh, yes, Your Honor.
As does the court. In particular, I find People's Exhibit number 1 lays out that on December 8th, 2025 in Cedar Creek Township of Wexford County, the victim and the defendant were in a motor vehicle and an argument ensued. At some point, the victim uses her phone to touch the defendant's phone because he seemed to be preoccupied on that phone. He takes her phone, throws it against the windshield, which causes a crack in the windshield. Also, it's alleged that, or at least I shouldn't say it's alleged, the report makes out that he punched her 3 to 4 times in the head, causing her then to go off the roadway and strike a snowbank. He admits that he blacked out in anger. The officers observed some red contusion near her right ear, and she complained of pain in her head. As I said, there was a potential self-defense claim in which he is claiming that she was striking him as well. Accordingly, I do find that the People's Exhibit number 1 does make a factual basis for domestic violence. I should also say they were a boyfriend, girlfriend at the time. I also find the interests of justice are well served in allowing the defendant to enter a no contest plea in order to not have any potential civil liability, have a guilty plea in this case used against him in a potential civil liability case. Now, counsel, because I am aware that there's been a violation of the no contact order, I should also ask Ms. Lawrence, was your victim okay with 4A in this case?
She was, Your Honor. She is here today, but I don't believe she wishes to speak.
I'm going to order a PSI in this case before we do sentencing. So we will set this for a sentence and order the pre-sentence investigation report. Is there anything else for the record?
Oh, thank you.
No, Your Honor.
All right. Ms. Lawrence, here is your exhibit. Mr. Burris, you can go back with the bailiff. All right. Number 255035 OD, the People of the City of Cadillac versus Alan Fernando Hernandez Cruz. Appearances, counsel.
Joanna, here, people.
Robert Hartel from Mr. Hernandez Cruz, who joins me at the table, Your Honor.
And we are here for a pretrial. Is there any resolution?
Yes, it's my understanding the defendant will be guilty to an added count 2 operating while visibly impaired. People will dismiss count 1 operating while.
I believe there's also a civil infraction for a refusal to take a PBT. Is that part of the agreement at all?
Was not.
All right. Mr. Hartel, is that accurate?
It is, Your Honor. If I recall correctly, I did preemptively forward a copy of my client's assessment to the court as well.
I have received that. Sir, have you heard what the attorneys have said the resolution in this case is? And is that how you wish to resolve it? All right. Will you please raise your right hand? As best as you can, do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Yes? All right, you may put your hand down. It's my understanding that you'll be pleading guilty to what is essentially an added count 2 of operating while visibly impaired. In exchange for that, that operating while visibly impaired is a 93-day misdemeanor, which means you could sit 93 days in jail and or a fine of $300. In exchange for that, the people will be dismissing the operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail with a fine of not more than $500. But there's some different licensing sanctions that go with your plea. Do you understand that?
Your Honor, if I may interrupt, I will dismiss the PBT review.
Additionally, the civil infraction for the refusal to take the PBT will be dismissed as well. Back on December 7th of 25, were you on probation or parole? Were you on bond? No. Do you remember reading and signing the advice of rights form and talk about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights? Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you in any way? No? I need you to say it. And is your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
And Hernandez Cruz, to the allegation that on or about December 7th, 2025 in the city of Cadillac in Wexford County, how do you plead to operating while visibly impaired? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on December 7th, were you in the city of Cadillac driving a motor vehicle? And prior to operating that motor vehicle, had you consumed alcohol? What is it that you'd had to drink? 2 beers. All right. And did consuming those 2 beers visibly impair your ability to operate the motor vehicle? Yes. All right. Do counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
I do.
As does the court, I find the plea is knowing, voluntary, and accurate. Sir, I find you guilty of operating while visibly impaired. Pursuant to the plea agreement, the operating while intoxicated will be dismissed. As already been mentioned, I've received the substance use assessment in this case. Ms. Carey, have you received that as well? Do either party have any corrections to it?
Thank you, Your Honor. I just conferred with my client. There are no corrections.
All right, allocution then, Martel?
Yes, Your Honor. I would ask the court to consider time served and then minimum fines and costs in this matter. As the court very likely recalls, my client does have an ICE hold. He's aware that he's going to have to deal with that. There's a very high chance of deportation. I don't do those type of cases myself, so I haven't given him any legal advice in that regard, but I do wish him the best with it all the same. He has been lodged pending resolution of this case. I do believe time served would be appropriate. I don't believe probation would be doable, to be frank, because of the situation with ICE. I believe when it would be taken, it would be out of state, if I understand correctly. And I don't believe any additional jail is necessarily warranted in this exact situation. Thank you.
Thank you. Ms. Carey,
No allocution, thank you.
what brought him to the attention of law enforcement?
At the road facing west, turn on 13th Street. The officer turned around, followed him, stopped him for defective headlights. But said the airline pulled into a private driveway. The officer parked and waited, and then he came back out on 13th Street, and then was speeding 70 and 55.
Mr. Hernandez Cruz, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
No.
All right, well, as Mr. Hartel has indicated, the defendant has not been able to postpone because of the immigration hold. I have reviewed the substance use assessment. It indicates that he does not have a disorder. Ms. Carey, just out of curiosity, what was do we have a blood draw or? The defendant has 31 days jail credit, so the sentence today will be 31 days with 31 days credit. There is a $75 crime victims rights fund fee, $50 state minimum fee, $200 fine, $150 court costs, $150 attorney fees. Is there any reimbursements requested, Ms. Carey?
Yes, to the city of Cadillac Police Department and the prosecutor's office.
$100 to the prosecutor. Was it a blood draw or breath?
Blood.
$300 to the city police department for the blood draw. Council, I believe that pursuant to MCL 780.73, I'm required to give 5 days, $5 credit for every day that he sat in jail towards his fine. So I hereby issue pursuant to that statute a credit in the amount of $155. Mr. Hernandez Cruz, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. And then because I have imposed jail, even though it's credit for time served, you do have the right to appeal that decision. And if you decided that you wanted to appeal it but could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. All right. Do you have any questions for me about your sentence?
No.
All right. You can go with the bailiff then. I'm sorry, counsel, anything else for the record?
No, thank you.
All right. You can go with the bailiff. Thank you.